In Vietnam, mergers and acquisitions, M&A, are not only about financial due diligence or corporate restructuring, they're also about people. When ownership changes, so do employment obligations. Whether it's a merger, acquisition, or business division, the buyer inherits the workforce and all associated liabilities under the Vietnamese labor law. Mishandling employee transfers can result in disputes, labor authority inspections, or even litigation. A compliant employee transition plan is not just good HR practice, it's a legal requirement that safeguards the entire transaction. Vietnamese law clearly defines employer obligations during business restructuring. Under Vietnamese labor law, when ownership, management, or structure changes, employers must ensure continuity of employment or negotiate mutual termination if continuation is impossible. Employees cannot be terminated solely due to ownership change. Instead, the successor company must either retain existing staff under the same terms or provide lawful severance if positions are no longer available. The law also requires a labor utilization plan to be prepared, consulted with employee representatives, and submitted to the competent labor authority before implementation. Before closing any M&A deal, the acquiring company should perform detailed HR and labor due diligence. This involves reviewing labor contracts and expiry dates, registered internal labor rules, ILRs, payroll, social insurance, and tax compliance, pending disciplinary or dispute cases, labor union or employee representation structures. These findings reveal potential liabilities, unpaid benefits, unregistered contracts, or misclassified employees that can affect post-closing compliance. LTS law frequently assists buyers and investors in pre-M&A audits to identify and mitigate labor risks early. Once due diligence is complete, both transferor and transferee companies must prepare a labor utilization plan under Vietnamese labor law. The plan should specify positions to be retained, transferred, or terminated, employees eligible for retraining or reassignment, timelines and communication procedures, severance or redundancy payments, if any. This plan must be prepared before the transaction closes and must be submitted to the competent labor authority. Without a properly prepared and submitted labor utilization plan, layoffs or transfers may be deemed unlawful. Transparent communication is critical. Employers must consult with employee representatives or unions about the proposed changes, obtain their feedback, and notify employees of how their contracts will be affected. Notice should be given within the statutory time frame before implementation. Even when the terms of employment remain unchanged, employees should receive written notice confirming that their rights and obligations continue with the new employer. Proper consultation builds trust and prevents resistance or complaints after the deal. Once the M&A is complete, the acquiring entity becomes the new legal employer. Labor contracts continue with the new employer if business operations and employment terms remain unchanged. However, if the new company does not require certain positions, it must terminate those contracts lawfully, not unilaterally. That means following redundancy procedures, consulting with employee representatives, and paying severance in accordance with Vietnamese labor law, half a month's salary per year of service. Any terminations outside this framework are considered unlawful dismissal. For employees who are terminated, employers must complete final settlements within 14 working days. This includes unpaid salary, unused annual leave, severance pay, and social insurance closure. For transferred employees, the company must update labor records and notify relevant authorities, including the competent labor authority, tax, and insurance agencies. Failing to update employment registrations can cause compliance gaps and expose both parties to inspection risk. If the new organization structure changes job roles, employers may offer retraining or redeployment options. Under Vietnamese labor law, employees who accept retraining retain their employment rights. Employers should issue clear agreements specifying the retraining duration, new job title, and revised salary. This step demonstrates goodwill and compliance, minimizing workforce disruption while meeting legal obligations. Beyond legal compliance, effective M&A transitions depend on HR communication and cultural integration. Employees fear job loss, uncertainty, and changes in benefits. Clear messaging about rights, timelines, and continued employment reduces anxiety and builds confidence. HR teams should coordinate with legal counsel to deliver consistent, bilingual communication throughout the process. In Vietnam, fair and transparent handling of employees reflects positively with both authorities and business partners. Even experienced companies often make critical mistakes, such as failing to prepare or properly submit the labor utilization plan, terminating employees immediately after closing without due process, overlooking severance obligations, ignoring union or employee consultation requirements, using notices or contracts without a Vietnamese version. Each mistake can lead to reinstatement orders, fines, and reputational damage. Legal precision in documentation and timing is essential. A Singaporean logistics group acquired a Vietnamese company with 200 employees. LTS Law conducted labor due diligence, identified unpaid social insurance liabilities, and drafted a full labor utilization plan. We guided both entities through the competent labor authority submission, consultation meetings, and contract transfers. The merger completed smoothly, with all employees either retained or compensated lawfully. Post-closing, the client passed a random labor inspection with no findings. At LTS Law, we provide end-to-end legal support for M&A employee transitions. Our bilingual lawyers draft labor utilization plans, review contracts, calculate severance, and liaise with labor authorities. We also conduct HR due diligence and train management teams on post-M&A compliance. For foreign investors, we align global restructuring objectives with Vietnamese labor laws to ensure seamless integration without disputes. In Vietnam, employees are the human side of every M&A. Mishandling them can delay deals and create liabilities that outlive the transaction. With proper planning, documentation, and legal support, employers can manage workforce transitions transparently and compliantly. If your company is planning a merger, acquisition, or restructuring, contact LTS Law today. We'll help you transfer your business, not your legal risks.